bless my soul, what's wrong?
This is Where You Live with Gene and Tony. We're broadcasting from the Concierge Landscape Studios. We're brought to you by Extreme Exteriors. Let's hear from the Community Associations Institute. This CAI Minute is brought to you by Start to Finish Maintenance Contractors. Start to Finish provides 24-hour service for all of your home and business maintenance needs. Call Start to Finish at 952-259-1219 for your home, for your business, and for your peace of mind. I have a couple of announcements about events at the Community Associations Institute in November. One is for board members. It's called Avoiding Legal Landmines. That will be on Wednesday, November 2nd. The second event is a manager's seminar for professional property managers. Underfunded reserves is the topic, and that's going to be presented by John Russo, who a lot of us know as an experienced engineer. You can call the CAI management at 651-203-7250 for more information about those events.
Yes. And folks, if you're just joining us here towards the tail end of our show, our guest right now is attorney Nancy Palomas with Helmuth and Johnson. We're talking about this association in Selbyville, Maryland, that the homeowners get things turned over from the developer, and they're upset because they think that the developer put them in a contract that's paying a lot more than what they should pay. And they're upset about it. Mm. But Nancy, you were bringing up a good point. You said even though the price may seem a little bit high now, if it's a long-term contract, it may be something that could be very beneficial to the association as time goes by.
That's correct. And if it is truly a bad, or what we lawyers call unconscionable contract, if it is an association governed by 515B or the Minnesota Common Interest Ownership Act, the association does have some availability to get out of that contract if they act relatively quickly.
And that's a great piece of information. I don't know that would be necessarily true in Maryland where this story took place, but here in Minnesota, folks, our listeners, if you are in a new association and you find some things unconscionable, there is hope. Nancy, tell our listeners a little bit more how this works.
Sure. Well, I'll talk mostly about associations that were created prior to August 1 of 2010, because that's going to be the great majority of associations. If a developer enters into a contract during the period that they control the association, so they're making all the decisions on behalf of the association, the association has the ability to terminate some of those contracts. They can terminate any management contract or employment contract. They can terminate any garage or parking facility contracts without regard to whether or not they're unconscionable. They can terminate a contract binding the association with, for example, a company that the developer owns. For example, some developers will form many different arms to deal with all of the issues of their communities, and then they'll contract on behalf of the associations with all those arms.
So they create a landscaping company or a grounds care company or a property management company, and then contract with their own subsidiaries to provide services. Okay, all right.
And so that might not be in the association's best interest long term, or if the contract is truly unconscionable or it was entered into in bad faith, the owners of the association would have the ability to terminate that contract without any penalties, as long as they do it within 2 years after the declarant turns over control.
Now,
interesting. Okay.
I would like to concentrate on this word unconscionable. Is there something that there is, if this is raised as an argument for wanting to have a contractor or a vendor leave, is there some proof that the association has to go through the show or prove what is considered unconscionable?
Well, to paraphrase one of the Supreme Court justices in a Supreme Court decision about pornography. I can't define it, but I know it when I see it.
That applies here. I see.
An unconscionable contract is really going to be a fact-based decision.
Okay.
It's going to vary from contract to contract. Yeah. Clearly, if you have a contract where the market price, we'll use the Selbyville case, the market price for a gallon of propane is $3. And this contract that the developer entered into requires them to pay $10 a gallon. That might be indicative of an unconscionable contract.
A reasonable person would say that's not.
Yeah.
That's right. Not okay.
Right.
Yeah.
Exactly.
Well,
and a reasonable person is really who we're looking at is, is this reasonably in line with other contracts of the same type?
Okay.
Now, there's probably been, I think, in Minnesota, a lot of cases that have set precedent when it comes to the person that is the one that's in control in writing the contract. Isn't there a greater responsibility or sort of a litmus test on that individual when it comes to upholding the terms of that contract and being responsible?
Well, yes and no. I mean, I think the provision you're talking about is that if there's an error in a contract, then the person who drafted the contract is basically going to be held responsible for that error, and they're not going to be able to take advantage of that error in trying to get out of a contract or enforce it if they know that it really was an error.
Yeah.
Normally, when you have two parties who are what we call of equal sophistication, they're both business people, they're both represented by counsel perhaps, that becomes less of an issue because then the courts say, look, you had experts or you had the business knowledge that you should have, we're going to hold you responsible for your agreement.
Now, certainly that would happen between a developer and a vendor or contractor. Would the courts look at when it gets turned over to the homeowner association the same way, or would they say we're not necessarily dealing with equals?
It's interesting. The few decisions that there are tend to treat associations as businesses, even though they are comprised of average Joes and Joannes. They don't necessarily say that that they are an unsophisticated party.
Yeah.
Oftentimes, because associations are not unsophisticated, they have the benefit of having a management agent, an attorney that they could turn to. Whether or not they do is really immaterial.
Yeah. Okay.
Well, I do like the way that they're looking at it then, because I think it should be looked at, in more as equals, because they are a corporation that is that has been put together by the state through the state of Minnesota, and they're recognized as such.
Exactly.
Yeah.
In this particular situation, I think it's important to remember that we don't know what the terms of this contract are, so it's a little hard to judge from the outside.
Exactly, and we don't know how long it's been in place. We don't know if Maryland has a statute similar to Minnesota's. So there are a lot of open questions that and I think just based on some of the statements in that story, I think there's more to the story that we're not hearing.
Yeah, I'll tell you.
That's
always
always
the case.
Well, say, Nancy, we just have a little more than a minute left here. For our listeners, once again, what are some of the most important parts of the state statute, and what does it say if someone feels that they are in an unconscionable contract?
Well, first thing is to look at them sooner rather than later, because there are time frames involved in how long you have to terminate those contracts. And then it's possible that you can work out a modification to the contract that is more workable. But if you can't, then absolutely there are provisions in the statute that would allow you to terminate a contract without penalty and move on to a contract that the association is more amenable to.
Probably always a good idea to consider having a clause that allows the association to give notice with or without cause.
If you can get it.
Yeah.
It's always a good idea.
That would be ideal.
Right. Well, folks, Nancy, thanks so much for being on the show with us today.
Certainly.
We appreciate your time. Folks, that was Nancy Palomas, a partner in Helmuth in Johnson. Well, it looks like we are all out of time for today. we want to thank you for being a part of the show. Folks, thanks for all your comments. Once again, if you have any other comments on today's show, give us a call on our hotline, 952-224-2668, and we'll air that next week. But until then, folks, have a great Sunday. See you next week.